Here we go. Let's be on the record in case number 2019 CR 1147, captioned State of Kansas. Hold on. My stream is talking back to me. There we go. All right, try this again. Calling case number 2019 CR 1147, captioned State of Kansas versus Zachary Arnold. Would the parties announce their appearances, please?
May it please the court, the State of Kansas appears by Assistant District Attorney Kayla Rayler.
Your Honor, may it please the court, Zachary Arnold appears in person through Zoom and with his attorney of record, James Spies.
Okay, so a little bit of a background. There was early on in this case an order for a competency evaluation. That evaluation was received and it found that Mr. Arnold was not competent to assist in his defense. However, Mr. Spies filed a motion to reconsider that, to have the defendant reevaluated. There were also motions for jury trial for the competency issue, as well as the appointment of 2 psychologists, all per the statute. As a preliminary move, I signed a new order to have Mr. Roberts reevaluate the defendant, given that most of these motions revolved around at least the allegations that the defendant's situation had changed from the time of the first evaluation. Mr. Roberts conducted that second evaluation and wrote a report of which the parties have received and the courts received. Basically, the findings of that report, although I see that it hasn't been filed yet, is that Mr. Arnold's state of mind has gone, in Mr. Roberts' opinion, to the point where he is competent to stand trial and assist in his defense. So I'm going to mark that report as states number 1, and I would ask if either party object to it being admitted for today's hearing.
Judge, I believe, wouldn't it be marked as defendant's exhibit 1 because this is on a defendant's motion, because the state's going to object to its admission because the state doesn't believe that under the statute that we can have Mark Roberts reevaluate him because the statute says that he shall go to learned.
All right. Well, okay. Mr. Spies, any objection to calling it defendant's exhibit 1?
No, Judge, I have no objection to the course of action proposed by Ms. Rayler. I would offer the Wyandotte Center report as my exhibit and ask the court to admit it. I understand Ms. Rayler will object, and I will let the court make its determination on that objection.
All right.
Can we do A instead of 1, please?
Defendant's A. Yes, I'm going to mark it as defendant's exhibit A then. And Ms. Rayler, do you want to make a record of your objection this morning?
Yes, Judge. It's a continuation of my objection to when the request was initially made that the statute doesn't provide for a mechanism after somebody has been deemed incompetent to have them reevaluated pre-learned because the statute says that they shall go to learned under 3303 for restoration and for treatment. There's no indication that there has been any restoration and treatment contained in Mark Roberts' report. No doctor has evaluated the defendant. The state has concerns if this case were to go up on appeal, what might happen because, again, the statute says he shall go to learned.
All right. Well, look, I suppose that it's possible that a defendant could request a rehearing on his competency, on the preliminary competency finding, because they disagreed with the finding of lack of competency, have that granted, and then turn around and appeal the fact that their request was granted. But I know what Court of Appeals generally do with what they call invited error. And I don't think it is error. I understand the way the statute reads, but I don't think that that precludes a initial assessor from receiving additional information and then reevaluating and seeing if the findings were the same. I think if this was flipped, if the state had requested this and that the defendant objected, that I would be more concerned about a defendant being able to come back later and say, you shouldn't have let Mr. Roberts take a second look at him. You should have sent him off to Larned per his first report. But that's not the case here. And I understand the state's objection. But Mr. Spees, I assume that it is your position today that I should adopt the findings of Mr. Roberts' second report and find that Mr. Arnold is competent to stand trial. Is that your request today?
Yes, sir, it is.
All right. State, your objection is noted for the record. It is overruled. I'm going to admit defendant's exhibit A. Ms. Rayler, when it comes to the finding of competency and whether I should adopt this, obviously you've taken a position contrary to that. Is there anything else that you want to add as far as argument as to competency before I make a ruling on the motion?
No, Your Honor.
All right. And Mr. Spees, anything else?
No, sir. Thank you.
All right. I am going to adopt the findings of Mr. Roberts' second report. Frankly, I think if the court was of a mind to not allow a second evaluation, that was the court's opportunity to say, no, the statute says he shall go to Larned and he's going to Larned. But in this court's view, particularly with the motion being forwarded by the defendant to have that reevaluation, and then Mr. Roberts finding that that he is competent, that it would be, what I would foresee is that we would send him to Larned. Larned would take Mr. Roberts' second report and turn around and send Mr. Arnold back to us without any kind of treatment or restoration, because the finding was that he did not need it at that time. So I'm going to find the defendant competent today. And Mr. Spees, what does that do to your motion for jury trial and the appointment of the individual psychologists?
At this point, it would make it moot unless the state were to file a motion of their own to have further evaluation of their own expert or something to that effect. So unless there's some further action by the state, I think those matters become moot.
I think so as well, as long as we are clear on the record that the defendant's intent for filing for the second evaluation, filing for the jury trial, and the independent psychologist was seeking a finding of competency. I would hate for it at some time to be raised that wasn't the defendant's request. They were actually seeking to affirm a finding of incompetency, but I'm comfortable with the defense statements that they were seeking a finding of competency to find that their request for a jury trial and the independent psychologist at this time is moot. Let me ask you, Ms. Rayler, you feel like, first of all, is the state entitled to file for a jury trial on the issue of competency, in your opinion? And I guess more to the point is whether you are or whether you aren't, is it your intent to do so?
Judge, I believe that the issue on a jury trial on competency is solely discretionary, that the way I read the statute, and forgive me, I did not reread the statute because I thought the court had already, I think, denied that previously because it was a may and not an absolute right to a jury trial on that. I believe either party, again, without rereading the statute, this is based off of the last time I read it, either party may request that jury trial. The state does not intend to request a jury trial on the issue of competency.
Okay, all right. So I'm going to find defendant competent today, and we'll figure that all of the other requests at this time are moot. So what would you all like a setting for? And before you answer that, let me tell you that it is my intent to order a mediation in this case at some point. Now, whether the parties would like it before a preliminary hearing or after is something that I'm willing to be flexible on. So I would hear first from you, Ms. Rayler. You know what? I think maybe first from Mr. Spees. Mr. Spees, if I am ordering a mediation, which I intend to do, would you prefer that that occur before or after the issue of the preliminary hearing is resolved?
Judge, I would like to have a preliminary hearing first. I think if there's not even been any evidence presented in open court, I don't think it would be prudent to move forward with a mediation. As far as the issue of mediation goes, that's a whole nother issue that we can certainly take up at another time. And it's entirely possible I may object to that. But the issue before us right now, I submit is one of, I would like to schedule a preliminary hearing.
All right. And I guess that kind of makes it, my intent was if either party wanted a prelim before I ordered that or considered ordering that, that I would grant it. So Ms. Rayler, do you have a position one way or another on that?
Judge, just as a procedural background, I believe that the initial competency order was done the first week that the case was on docket. So there haven't been any sort of negotiations between the state or the defense. So without coming to a stalemate where mediation would be beneficial, I don't know if now would be the appropriate time prior to a preliminary hearing to having a mediation.
All right. Well, you know, I do think that, not that I would substitute myself either.
Judge, your voice, your volume has gone way down.
Okay. I don't know. My computer just unplugged itself for a second, but it should be fine. Can you hear me now?
I'm still not hearing you. I mean, I can hear you, but you're so quiet, I can't understand you.
Huh. All right. 1 second. Let me solve this problem. My microphone is on. Yeah, it shows that it's barely responding right now.
You're good now.
You're
Okay.
better.
All right, then we're gonna go through this. Now, the second issue that comes to my mind is there hasn't been any kind of motion filed for regarding self-defense. Before I schedule you a preliminary hearing, Mr. Spees, do you intend to file any such motion, which obviously has to be filed and heard before preliminary hearing?
Judge, correct me if I'm wrong. I thought the court's procedure was to conduct a hearing on such a motion at the same time as a preliminary hearing. I thought that's how we were doing it. And it is our intent at this point to file that motion.
All right. So yeah, that would be my preference as long as everybody is fine with that, to do that at the same time. So, all right. Is the next setting you want for a go preliminary hearing along with
Yes.
this motion? All right.
Yes.
All right. Ms. Rayler, do you have an idea how long you will need to be prepared for a preliminary hearing / motion for self-defense immunity?
The state can be prepared in 30 days. It may just depend on when Mr. Spees files his motion. If there are new allegations raised in his motion, the state needs time to consult with the detectives and any other witnesses or parties that may be material to that particular issue.
Sure, sure. Mr. Spees, do you have an idea of a time frame when you're going to file that?
Judge, yeah, here's my thought process on that. I would think, if it's acceptable to the court and Ms. Rayler, to look for a preliminary hearing date, perhaps more about like 45 days down the road. That would give me, and perhaps you could give me 3 weeks to file the motion. 3 weeks from today, that would give Ms. Rayler time to reply, and I think also time to do anything else she would need to do on her end.
That's, do you think, so that would be taking up 21 of the 45 days. So does that seem like something, Ms. Rayler, that you're going to be able to do?
Yes, Your Honor.
All right.
I'll make it work.
All right. Before, well, my assistant isn't on our Zoom today, so I'm going to email her along with the two of you, requesting a date and you know, the other question is, do we need a full day, half a day? What do you think?
Judge, I
Um,
believe the state would anticipate calling 1, maybe 2 witnesses. Obviously, if it's a self-defense immunity claim, the defendant's going to have to testify. I would
Right.
suggest, out of an abundance of caution, I don't know how long it's going to take, half day to be safe, at most blocking out the entire day on the extreme end.
All right, Mr. Spees, I think that's the voice of reason. Yeah,
Correct.
I rather always be safe. I'll block out a whole day. Do not in any way feel obligated to take up all that time. So I will send an email to the parties and to my assistant requesting a date 45 to 60 days out for a full day preliminary hearing setting. And Mr. Spees, you are ordered to file the self-defense motion if it's going to be filed within 21 days.
Okay.
All right. Other things for our record today.
No, Your Honor.
All right. We
Not
are
from
adjourned.
us.
All
Thank
right,
you.
we are adjourned. Thank you, everyone.
Thank you.